So I want to talk briefly, or maybe not, about the difference between human rights and wrongful dismissal in terms of the onus of proof and what is the evidence required to show the case. So in a wrongful dismissal case, it's pretty simple. The employee must show there's a termination, and then the employer must show there's either grounds for termination, there's just cause, or there's a contract, or whatever the defense may be. It's a relatively simple process. Human rights is more complicated. So in a human rights complaint, the individual has to show what is called a prima facie case, basically meaning that I'm going to show a case sufficient to show liability, and it's a low bar to show a prima facie case, and then the employer has the option of defending it or disproving the prima facie case. That's the basic components. So to succeed on a human rights complaint, the individual has to show that he or she is a member of a protected group, that is, whatever the issue is. I'm a woman treated adversely, and that's the second issue, the adverse treatment. But more importantly, the adverse treatment in a human rights case does not have to be the only reason for the termination if it's a termination case. It only has to be a factor of influence. So there could be 5 other factors that the employer says justify the action, but if the human rights issue is a factor of influence, it's enough to create liability in this first part of the case to show a prima facie case. So it's a relatively low bar to show a prima facie case, and once that has been proven, then the employer has the option of showing, either disputing the facts leading to the prima facie case by affirmative evidence, or it can produce a real and justified reason for the action taken. It has nothing to do with the alleged human rights violation. For example, there was a case in which a woman sued the Board of Education saying she was denied a promotion because of her gender, and the Board of Education said, well, no, not really. We have a policy of how these promotions are done. It's based on performance issues, seniority, blah, 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 and nothing to do with your gender. And in that case, the employer succeeded in its defense. Now, at the end of the day, when the case is finished, the decision maker has to decide if it's more probable or not that a case has been made out for adverse treatment due to a human rights violation. Again, keeping in mind that the test is whether the human rights issue is influential in the decision. And the decision maker can also use an inference. It can decide based on an inference that there's been such a factor present of an influence to create a human rights violation. So in human rights decisions, it's fairly easy, I should say, it's easier to show liability than you might expect. And once liability is shown, then there's an issue what damages will flow from a consequence of that. So these are 2 different altogether processes, and it's important to understand the difference. And as I mentioned, the damage claims are much, much different depending on which forum is chosen.